state of Tennessee and this honorable court. Please be seated.
Good morning and welcome to this session of the Tennessee Supreme Court here at Boyd State. Also welcome to all of those who are watching by live stream on our YouTube channel. Our Scales Project brings together judges, attorneys, and students to develop a better understanding of the judicial branch of government and the roles of the courts in our society. Unlike cases you see on TV, today you will hear real cases with real lawyers representing real clients and real judges deciding these issues. We appreciate your participation. We hope you will enjoy the case you hear today. I want to thank Tennessee Tech University and Dr. Philip Oldham, President of the University, Jason Murphy, Tennessee American Legion Boys State Chair, Judge John Maddox, Vice Chair, and all of the delegates and staff at this year's American Legion Boys State who have worked so hard to make this event possible. We would also like to recognize the following law enforcement agencies who are assisting us with the security for today's program: the Tennessee Highway Patrol, the Cookeville City Police Department, the Putnam County Sheriff's Department, Tennessee Tech University Police, and the Putnam County Emergency Medical Services. And thank you as well to the attorneys who are arguing their cases before us today and for the extra effort and time required for your participation. We appreciate that. We know it's an extra drive and extra participation. We hope all of you will stay engaged with the judicial branch after court today. You can follow us on Twitter at TNCourts, on our website, tncourts.gov, and on Facebook. The opinions we write on today's cases will be posted to our website and to our Twitter feed. Now I want to introduce the justices of the Tennessee Supreme Court in according to their length of service with our court. To my immediate right is Justice Sharon Lee. She is a past Chief Justice of this court and a graduate of the University of Tennessee with a degree in accounting and the University of Tennessee College of Law. Justice Lee practiced law in her hometown of Madisonville before being appointed to the Court of Appeals. After serving on that court for a number of years, she was appointed to the Tennessee Supreme Court in 2008. She is from Monroe County. To my immediate left is Justice Jeff Bivens. He is also a past Chief Justice of this court. He is a graduate of East Tennessee State University with a major in political science and a graduate of Vanderbilt University School of Law. He practiced law in Nashville, served as Assistant Commissioner and General Counsel for the Tennessee Department of Personnel, and has served as a trial court judge and a judge on the Court of Criminal Appeals. He has been a justice on this court since 2014 and lives in Franklin. My far right is Justice Holly Kirby. She graduated from the University of Memphis with a degree in engineering and from the University of Memphis School of Law. She clerked for Judge Harry Welford of the Sixth Circuit Court of Appeals and then practiced law in Memphis. She served on the Court of Appeals for 19 years before being appointed at the Supreme Court. She lives in Memphis. To my far left is Justice Sarah Campbell. She earned her bachelor's degree from the University of Tennessee at Knoxville, a master's degree from Duke University, and her Juris Doctorate from the Duke University School of Law. She served as law clerk to the Honorable Samuel A. Alito Jr. on the United States Supreme Court. Prior to her appointment to the Tennessee Supreme Court in 2022, she was Associate Solicitor General and Special Assistant to the Attorney General in the Tennessee Attorney General's Office. I'm Chief Justice Roger Page. I'm a graduate of the University of Tennessee Health Sciences Center and the University of Memphis College of Law. I practiced law for 14 years before being elected circuit judge. I was appointed to the Court of Criminal Appeals, served there for a number of years, and then was appointed to the Supreme Court in 2016. I live in Chester County in West Tennessee. As you can see, we're from different parts of Tennessee and went to different law schools. We all consider it a great privilege to serve on the highest court of this state. We are committed to upholding the constitutions, protecting individual rights, and applying the laws fairly across the state. We're now ready to get to work. Mr. Hivner, Jim Hivner, who is our appellate court clerk, will now call our case.
State of Tennessee versus Ebony Robinson.
Good morning, and may it please the court. I am Emmy Tennant of the Nashville Public Defender's Office, appearing today on behalf of our client, Ebony Robinson. I would like to reserve 5 minutes of my time for rebuttal.
Can you bring the microphone a little closer to your, just tilt it a little?
Of course.
Yeah, that's better.
Is that better now? Okay, thank you.
That's good.
Ms. Robinson pleaded guilty to the offense of vehicular homicide by intoxication. These are incredibly sad and painful facts. The accident took the life of one little boy and caused injury to another little boy. We're here today basically because Judge Mark Fishburne sentenced her, and the state of Tennessee appealed that sentence. The Court of Criminal Appeals reversed the sentence, and we are here before you now. At sentencing, Judge Fishburne considered the evidence in the case, the principles of sentencing, Ms. Robinson's personal characteristics and background, and the interests of the community. He also analyzed 2 sentencing directives from our legislature that seemed to point in 2 different directions. The first was a 2015 amendment to the vehicular homicide statute that set forth a mandatory minimum framework for people convicted of vehicular homicide by intoxication. That amendment was adopted, like I said, in 2015 and became effective that year. He also considered a 2016 amendment to the probation statute 4035-303A, which listed vehicular homicide by intoxication among the offenses that are ineligible for probation. So here we have 2 statutes enacted essentially 1 year apart that deal with the same general subject area, sentencing options, and that seem to suggest 2 different outcomes. The trial court looked at these provisions and examined them within the context of the entire Sentencing Act, noting that the legislature is presumed by our courts to be aware of its prior enactments when it passes a law. And the trial court also relied on Tennessee Code Section 4035-104, which sets forth several different forms of alternative sentencing, and again relied on the express terms of the vehicular homicide statute 3913-213, which sets forth this mandatory minimum framework. And he decided that people like Ms. Robinson, convicted of vehicular homicide by intoxication, are eligible for split confinement and periodic confinement. He put together a sentence composed of those 2 alternative sentences, and in so doing, avoided a outcome that held those 2 statutory provisions to be in conflict with another. He undertook an analysis and sort of made them work, made them be in accord.
Ms. Tennant, if I could interrupt you there,
Yes,
can
ma'am.
you explain why, in your view, there's a conflict between these statutes? And I'll just tell you sort of where I am on this. I mean, since the vehicular homicide by intoxication statute expressly references the probation statute, you know, it's subject to that statute is one way of looking at it.
That is one way of
you know,
looking at
the vehicular homicide statute doesn't itself entitle any defendant to probation. It just says that sort of if probation is available under this other statute, you know, here's how this will work. Why do you, I take it you read it differently, or at least that you read it in a way that suggests that there's a conflict. So can you help me understand your position on that?
I don't know that I would say that I read it in a way that means that there is a conflict. I think that they do, at first blush, appear to, like I said, sort of point in 2 different directions. Here is a framework, 4 paragraphs of law that set forth this mandatory minimum sentencing scheme. And then here is this provision that discusses probation eligibility. I think that as Judge Fishburne recognized when he evaluated them, legislatures are presumed to know the status of the law when they pass a law. And in this case, possibly, looking at the possible intent behind them, they weren't in conflict, but perhaps the provision in 4035-303 was set there to clarify that full probation is not allowed under 4035-303, but in reference to the vehicular homicide statute, you still have available alternative sentences such as split confinement and periodic confinement, looking at the express terms of that statute.
do you think that your reading of probation is the best reading of that term in the probation statute, or is it one that you think is a reasonable reading that we should adopt because of this, I guess I'll stop short of saying conflict, but because of some tension between the statutes?
I think tensions is a great word choice here, and I think that it is the duty of the court in looking at two statutes which may not at first blush appear to be in accord is to find a reasonable explanation and have them be in accord, make them harmonious, given all of the different assumptions that a court makes about what a legislature is doing when it is passing laws. Generally speaking, when a legislature is passing laws, it's doing so to change the law or to clarify the law. And here we have the legislature potentially clarifying the law about full probation with regard to vehicular homicide by intoxication.
But the probation statute, I mean, it doesn't apply only to vehicular homicide. It lists a whole bunch of other offenses that are ineligible for probation. And so the reading that we adopt of the term probation in that statute is going to affect not only whether a defendant convicted of vehicular homicide by intoxication is eligible for probation, but all of these other offenses that are listed there, isn't that right?
I think this court can adopt a reading that recognizes the specific carve-out in the offense of vehicular homicide. When you have in the actual statute that sets forth the prescribed conduct, when you have reference to the sentencing options set forth in that statute, which isn't typical in most statutes. Most statutes that prescribe offenses don't set forth the different sentencing provisions. They may set forth what classification of felony it is, but they, generally speaking, don't carve out paragraphs of law regarding sentencing options and mandatory minimum sentences. Here, I think a possible place this court could arrive is that with regard to that specific law, and given that carve-out, given that very specific language, which the legislature has not changed, we can recognize that for that offense, 4035-303 prohibits full probation, but that the other sentencing options are still available.
So we would read the term differently depending on which offense is at issue?
I think recognizing what is actually listed in those provisions, so the other laws referenced in 4035-303 for the most part do not have any specific sentencing references in them. The only one that does is, I believe, 3913-352. I may have gotten that cite wrong. 532, statutory rape by an authority figure. If you go to that code section, it sets forth the prescribed conduct. It also references that probation shall not be available for that offense and judicial diversion shall not be available for that offense. Blanket statement, hard and fast, no option. The rest of the code sections listed in 4035-303A do not have any reference to a particular type of sentence other than, like I said, the classification, the felony range.
Perhaps ask it, the follow-up, Justice Campbell's, it'll ask it a little different way. So you would have us essentially infer the word full into the prohibition on probation for vehicular homicide, correct? And so in other words, it would be that there could be, that this only prohibits full probation, correct?
Yes, I think that is the reasonable place to go with when considering the tension between these two statutes.
So you would have us infer the word full into one of these multiple statutes that are listed here, but not the others. Can you cite us another example of when this court has looked at a statute that lists multiple other crimes or statutes and we've interpreted one of those differently than the others?
I do not have an example of that regarding this court. There is a Court of Criminal Appeals case that did not deal with the sentencing issue. I've cited it in my reply brief, but it does deal with when looking at statutes that may be in apparent conflict or in tension and looking to save the statutory meaning of those two provisions. They've used words that aren't in the code. In that particular case, State versus Pruitt, a reading of the scheduling of drug code section left unclear where hydrocodone mixed with acetaminophen, what schedule drug that could be. If it were one, it would, if it were a Schedule II drug, it would render superfluous the language making it a Schedule III drug, and vice versa. They used the sort of helpful modifying words of pure hydrocodone and diluted hydrocodone. Those words don't appear in the text, but in order to make both provisions have meaning. And I would suggest that using the word full probation here, which is something that courts recognized. It's recognized in our case law. Full probation is a thing that is distinct from other alternative sentencing options. Using that word here would best preserve the vitality of both of these code sections.
So counsel, looking at it from a different angle, if we presume the word probation in 4035-303 is ambiguous, what does we can turn to legislative history. What does legislative history tell us about this amendment and what the legislature meant by probation here?
I could not find anything all that meaningful or helpful in the legislative history, Your Honor, and I apologize, I will not be able to give you any specific references to that. I do know that at least one legislator was hoping to clarify that people would still be eligible for community corrections. I'm not sure where that leads us, and I don't... Oh, go ahead.
That'd be a form of probation, wouldn't it, or a...
Well,
it's a form of release into the community, for sure,
well,
yes.
you would concede that probation and community corrections are not the same thing. Community corrections is much more supervision of a defendant, correct?
Yes.
And also, would you not, I guess, acknowledge that at the time this was passed, that the legislature was, I'll say, cracking down, for want of a better phrase, on vehicular homicide? So they were trying to make it where you had to serve a lot more time for that? I mean, there was a time in this state, if I think I'm correct, where we had the mandatory minimums for DUI, but not for vehicular homicide.
So we have yes, Your Honor, in 2015, they took the DUI mandatory minimum sentencings and lifted them over to the vehicular homicide by intoxication statute, and it's all in there with the same sort of graduated sequence of minimum jail terms, the 48 hours, the 45 days, the 120 days, et cetera. That same General Assembly, 1 year later, did something that at first blush looks contradictory, but I would say was clarifying, that they really wanted to make sure that nobody convicted of vehicular homicide by intoxication was entitled to full probation.
Well, but wouldn't the mandatory minimums that they enacted the year before already preclude the award of a full probationary sentence?
It would definitely appear that way when you look at the two statutes side by side. Again, I think when a legislature amends a law, it does so either to change it or to clarify it, and it'd be our position that they were clarifying it here.
But in essence, what you could have, a reasonable interpretation here would be that they were simply taking building blocks on that, weren't they? That they were as Justice Page mentioned, the kind of cracking down on vehicular homicide. So step one was to say, well, you have these mandatory minimums. Step two was to say, by the next year, they're going to say, you know what, we're just going to say no probation whatsoever. Isn't that a reasonable interpretation of the statutes?
It may be, but our duty, a court's duty in interpreting statutes is to not look behind and look at that process unless the statutory language is unclear. And here I think we can reasonably find these statutes to be in accord with each other and come up with a reasonable way to make them both work.
Would you agree that we have to look at context when we're interpreting a statutory context, so surrounding provisions, how the word is used, and related provisions of the statute?
Typically when the language itself doesn't allow a court to ascertain legislative intent, then the broader statutory scheme can become relevant, yes.
So I want to point you to 303C1. So that provision says, if the court determines that a period of probation is appropriate, the court shall sentence the defendant to a specific sentence, but shall suspend the execution of all or part of the sentence. And then it continues, but that's the language I'm concerned with here. I mean, doesn't that presuppose that probation could mean a sentence of full probation or split confinement or periodic confinement?
Yes, and there are other aspects, there are other sections in the code which specifically set forth split confinement and periodic confinement as sentencing options that are available to a court. They are listed among the 8 or 9 different sentencing options.
In the alternative sentencing statute, is
The
that what you're
alternative
referring
sentencing
to?
statute, and then they're also specified in their own code section. 4035-306 specifically authorizes sentences of split confinement, and code section 4035-307 specifically authorizes periodic confinement.
And don't, I mean, the alternative sentencing statute itself, when it's referring to split confinement, I mean, it uses the term probation to describe that. So don't those contextual clues point us to a reading of probation that includes both full probation and partial probationary sentences such as split confinement or periodic confinement?
I think that split confinement and periodic confinement are both sentences of confinement and sentences of probation. I don't know that that declaring that means that it is unworkable to decide that full probation is precluded for vehicular homicide by intoxication, but those alternative sentencing options are not. I get a ruling that would declare otherwise, that would find that that Ms. Robinson is not eligible for any form of release into the community, would essentially repeal by implication the entire mandatory minimum sentencing framework set forth in 3913-213. And it has been a policy of this court, and for very good reason, to avoid repealing code section by implication when at all possible. Why is that the last resort? There are important policy considerations, separation of powers issues at play when a court interprets legislation. Courts, of course, do not legislate, and courts should hesitate to decide that a legislature has acted when they have actually just been silent. Here, the legislature has been silent on this apparent tension despite many opportunities to go back and clean it up. And there could be many legitimate legislative processes at play there. Certainly, the precise lines drawn by any statute may reflect legitimate legislative processes that are not apparent, but need to be respected when interpreting legislation. When a court finds repeal by implication or by silent repeal, it is essentially presuming that the legislature just forgot to do some housekeeping. Here, that presumption is especially fraught because, again, we have these two legislative enactments done within or in 1 year apart. The exact same legislative body, the 109th General Assembly, passed them. They even shared a common House sponsor. Moreover, the legislature has not changed or cleaned up the vehicular homicide by intoxication statute, despite many opportunities to do so. The first being after the Court of Criminal Appeals acknowledged that split confinement remained a sentencing option for vehicular homicide by intoxication in 2019 in the case of State versus Johnny David Key.
We are usually very reluctant to infer anything about the legislature's intent from inaction. I mean, there are a lot of reasons why the legislature may not have acted to further clarify or to clean things up.
It is always, and that is why repeal by implication itself, the silence is also a dangerous, or is a fraught assumption in many situations. There could be many reasons that they allowed two statutes to stay in some tension with one another. That could reflect some unrecorded political compromise that we don't know about and can't see. On the other hand, here they actually went back into the vehicular homicide by intoxication statute in 2021 to broaden its reach. I believe they added all vessels that are powered by sail or machinery to its provisions. And even then, despite the key case in 2019, despite what they did in 2015 and 2016, they didn't clean up the language then either. It's still there. It is still approximately 273 words in our code. And I'd say it's a very big act to just assume that's all there by oversight at this point.
Ms. Tennant, to be fair, in the Key case, wasn't that defendant sentenced to serve the full sentence without probation?
Yes, it was up
So
there.
the comment about whether he was eligible for probation could be considered dicta, correct?
So the court in the Key case was reviewing a sentence imposed by a trial court. The defendant got a sentence to serve, and he appealed that. And the court, in noting the various sentencing options available to the court, started its analysis by saying that the vehicular homicide by intoxication statute would not have prevented split confinement in that case, but that the defendant, they upheld the sentence. It wasn't otherwise a suitable candidate for release into the community.
So dicta or not?
I wouldn't call it dicta because you have to start with what's available, what would have been available to the trial court. They weren't expressly examining what we are examining here today, but they were expressly examining the sentencing options that may have been available to the trial court when the trial court decided to sentence him to a sentence of continuous confinement.
I guess my point is you cited inaction by the legislature, and I'm not sure a legislator reading that case would take away from it that we need to fix this because the guy didn't get probation anyway. Is that
Possibly
fair?
true, but they are, we do presume that legislatures are aware of prior case law. I think more the fact that they've gone into that statute since 2015 when they added the mandatory minimum sentencing framework, since 2016 when they added the provision to 4035-303, and then broadened the reach of that statute without doing anything about literally 4 paragraphs of text. That's a very large step to say that those. This is the statute that prescribes the conduct. This is the offense. This is what a member of the public would look to find out what is illegal when it comes to vehicular homicide, and they see these references to split confinement. I am not saying that there's a huge notice violation here, but I do think that it is important that this language is preserved in the offense itself, whereas the language that leaves us here in question, 4035-303, is in a probation statute that is not necessarily tied to that specific prescribed conduct.
Well, isn't one possible explanation for why the language may have been left in the vehicular homicide statute the possibility that 303, the probation statute, could be further amended? I mean, it expressly incorporates the probation statute.
It does, Your
So
Honor.
that if the probation statute changes, then that language in the vehicular homicide statute could once again become meaningful. If all of a sudden vehicular homicide by intoxication were taken out of the list of ineligible for probation offenses in Section 303, then that language would certainly be relevant in the vehicular homicide statute. So it's sort of a backstop in the case that Section 303 is further amended. I mean, doesn't that provide an explanation for why it might still be there? To provide for, I guess, flexibility going forward if there are further amendments?
I think that sort of a placeholder, I think that still invites a lot of confusion, and I think, and also just sort of means that those 4 paragraphs are temporarily superfluous, whereas what the trial court did here, and what I'm asking this court to do, is find a way to actually give vitality to both of those provisions, to hold them in accord, to make them work so that they both have some meaning going forward. And I think it is possible to do that by recognizing that full probation is an aspect of our law. It is discussed in case law. I mean, as recently as, cases coming out nearly every week use the concept of full probation to talk about the burdens of proof at a sentencing hearing. versus other forms of alternative sentencing, and recognizing that's important in and of itself, and it is a way to hold both of these statutes in harmony and not have those 4 paragraphs be either temporarily or fully inoperative. If there are no further questions, I will come back at my rebuttal time. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Garrett Ward, and I'm here today on behalf of the state of Tennessee. Your Honors, the defendant in this case, while above the legal limit, playing on her cell phone, and without checking her rearview mirror, rapidly reversed her vehicle, striking 2 young boys who were bicycling, killing one and hospitalizing the other. Based on these actions, she was convicted of vehicular homicide by intoxication. This offense is under the state of Tennessee's probation eligibility statute, not an offense for which a defendant may receive probation. Despite this, the defendant received at the trial court level a sentence suspended to probation accompanied by periodic confinement for about 2 weeks a year. The state subsequently appealed this sentence to the Court of Criminal Appeals, arguing that the defendant's statutory ineligibility for probation rendered her statutorily ineligible for this probationary sentence. And the Court of Criminal Appeals agreed with the state's argument here. And Your Honors, what we're really here for today is to look at the interplay between 2 statutes, the probation eligibility statute, which I mentioned previously, and the vehicular homicide statute. In particular, the vehicular homicide by intoxication subsections of that criminal offense. So I think really the only place to start in this case is looking at the plain language of both of those statutes. Turning first to the vehicular homicide statute, what this statute says, in the most relevant portions regarding release on probation, is that a defendant convicted of a first vehicular homicide by intoxication offense, quote, shall not be eligible for release from confinement on probation pursuant to the probation eligibility statute until the person has served a mandatory minimum. On the other hand, the probation eligibility statute plainly states that a defendant may only be considered eligible for probation if the sentence actually imposed upon the defendant is 10 years or less, and if the defendant is not convicted of a violation of it. And there's a long list of enumerated offenses, which includes vehicular homicide by intoxication.
So if the legislature really meant to remove all probation, why, when they passed 4035-303, why did they not repeal these mandatory minimums in 3913-213? They're directly contradictory.
I've got a couple of points on that, Your Honor. One, I don't view the plain language of these 2 statutes as being in direct conflict.
One says serve 48 hours and go home. The other says no probation.
Well, respectfully, Your Honor, the vehicular homicide by intoxication statute does not say serve 48 hours and go home. It says a defendant convicted of this offense shall not be eligible pursuant to the probation eligibility statute until that 48-hour mandatory minimum. So I don't think the plain language of that statute sets forth a point, 48 hours, where a defendant will be eligible for probation. What it does is sort of set a floor, an early point, the first point at which a defendant could possibly be eligible for probation. And when it does that, it directly references the probation eligibility statute with all of its sort of limitations to its full context.
So what's the meaning of 48 hours then? I mean, it has no meaning under 4035-303, does it?
Your Honor, while 4035-303 does, it is explicitly incorporated in this vehicular homicide statute. So in a sense, this vehicular homicide statute incorporates this prohibition on probation that is included in the probation eligibility statute. in a way, the vehicular homicide statute, what it says on terms of probation eligibility is what the probation eligibility statute says goes on this topic.
But in practical terms, do you agree that 4035-303 requires a defendant to serve a full 10 years? And if you have to serve a full 10 years, then what is the meaning of a 48-hour mandatory sentence?
Perhaps, Your Honors, it does sort of lessen the work done by the vehicular homicide statute, but I don't think what it does not do is conflict with that statute.
How does it not conflict? If I'm sitting there and the defendant, my lawyer says, you plead to this, you're going to serve 10 years. And I say, oh, but wait, this other section over here says I only have to serve a mandatory 48-hour sentence, and then maybe I can be released. I mean, are those not directly contrary to each other?
Your Honor, I don't believe so, because what that vehicular homicide statute also says is that you must look, if you're this hypothetical defendant, you must not look only at this statute,
Okay.
but also at the probation eligibility statute. So when looking at those two statutes together, I think that defendant would be left with the rather clear conclusion that they may not receive probation. That because the vehicular homicide statute...
They might not, or they won't receive probation?
When I say may not, I mean they are not allowed to receive probation because
Okay.
they are ineligible for it.
So your argument is that these statutes are not ambiguous when they're read together?
I see no ambiguity, Your Honor.
Okay.
There is no guarantee in the vehicular homicide statute of probation eligibility.
But
it is certainly contemplated to some extent. However, it is contemplated to this extent only within the bounds of the probation eligibility statute itself, and the probation eligibility statute says in no uncertain terms that a defendant in the situation of Ms. Robinson is not eligible for probation.
But isn't Ms. Tennant correct in that essentially what we would be saying if we adopt your position is repeal by implication?
Perhaps, Your Honors, I think that the repeal by implication doctrine is most typically cabined to situations where the statutes are wholly irreconcilable, while a holding from this court saying that a defendant convicted of vehicular homicide by intoxication is ineligible for probation sort of lessens the effectiveness of the vehicular homicide statute. I don't believe this court is bound to, if it agrees with the state's position, this court is not bound to say that these two statutes are irreconcilably in conflict such that the amendments, the later amendments to the probation eligibility statute repealed by implication the mandatory minimum language in the vehicular homicide statutes. Certainly, Your Honors, to the extent this court does view these statutes as being in conflict, I believe opposing counsel said there's some tension here, and perhaps there is, but to the extent this court cannot reconcile that tension, then there is only one possible outcome, and that is to give full effect to the later arising statute here, and the later arising amendment is the one to the probation eligibility statute that made a defendant convicted of vehicular homicide by intoxication statutorily ineligible for probation.
Do you read the Court of Criminal Appeals opinion as saying that as holding that there is an implied repeal?
I don't read it that way, Your Honor. I believe the proper way to read the Court of Criminal Appeals opinion, both the opinion in Robinson and then another recent opinion in McKinney, is saying that there is no irreconcilable conflict between these two statutes because of this explicit and unambiguous reference to the probation eligibility statute in the vehicular homicide by intoxication statute. Because of this explicit reference, that it incorporates all of the limitations and prohibitions and eligibility determinations in itself. And therefore, there's no conflict necessarily. I think that's the principal holding of the Court of Criminal Appeals in this case. However, the court did make what I'll couch as an alternative holding that to the extent there is an irreconcilable conflict between these statutes, that there would be repeal by implication. I think that is the most appropriate way to view the
So
CCA's opinion here.
what is the standard that we use in looking at these two statutes together? Are we required to figure out a way that they can be both interpreted and both have some effectiveness? Or do we look for the best reading of each statute?
So, Justice Kirby, as is the case with sort of most cases that principally involve statutory interpretation, this court's sort of initial directive is to look to the plain language of the two statutes and try to give try to adopt a reasonable reading of both statutes that gives full effect to the intent of the legislature and is harmonious.
Are we required to, even if it's not the best reading of one statute or the other, are we required to interpret them in a way that doesn't render one of them just nugatory?
I wouldn't necessarily say required, Your Honor. This court has sort of recognized that there are occasions where, perhaps repeal by implication or sort of rendering other language surplusage has happened. Sometimes sort of in the legislative process while the sausage is getting made, these sorts of things occur. So there's not a requirement that such a...
So if we have a choice between an interpretation of a statute that we think that's the most natural reading of the language in the statute, but on the other hand, we have this other interpretation that renders it more, less inconsistent with another statute. Under our standards, which are there standards that say we have to pick one over the other?
Your Honor, if sort of the second option there, the second option of reading the two statutes still gave full effect to the intent of the legislature, I don't see necessarily any problem with that. The issue, though, in this case is given the language used in the probation eligibility statute, given the language used in the authorizing statutes for split and periodic confinement, given the language used by this court in previous cases not adopting, but examining these types of sentences, there's no way to give full effect to the intent of the legislature by sort of adopting a reading that would allow for, in essence, probation eligibility, just not full probation.
What should we make of the fact that Section 303, the probation eligibility statute, applies to a whole lot of offenses, not just vehicular homicide? I discussed this with Ms. Tennant and she suggested that we could, and I think I'm stating her position correctly, that we could construe probation to mean one thing in the context of vehicular homicide without necessarily extending that meaning to everything else. Do you agree with that? And how should that factor into our analysis, the fact that Section 303 is broader? It applies, the language of that statute applies in a lot of other contexts.
Justice Campbell, I think the best conclusion to glean from vehicular homicides by interpretation's inclusion in Section 303, the best conclusion to draw is that the legislature wanted it to be treated, and by it I mean vehicular homicide by intoxication, wanted it to be treated exactly the same as all of the other offenses in this enumerated list, and exactly the same as a sentence that is in excess of 10 years. And when I say that, when I say exactly the same, I mean ineligible for probation. This is a very specific statute that sets out probation eligibility. It speaks not in terms of, it doesn't parse its discussion of probation in terms of full probation versus split confinement versus shock probation versus periodic confinement. It renders defendants receiving sentences over 10 years or committing one of a list of offenses ineligible for probation. The legislature, with full knowledge of their sort of earlier actions in amending the vehicular homicide statute, specifically and deliberately added vehicular homicide by intoxication to this list. Its inclusion in this list clearly indicates that the legislature's intent is to have it be treated the same as all other items in this list.
What about the fact that if there was an amendment to the vehicular homicide statute in 2021 and the legislature chose not to address these issues, how do we factor that into our analysis?
Your Honor, the legislature's sort of subsequent amendment in 2021 of an unrelated subsection of this statute, which is relatively lengthy, should not factor into this court's analysis at all compared to the very relevant and specific amendments of the sort of probation eligibility criteria in 2016 and 2017 of the vehicular homicide and probation eligibility statute. The sort of subsequent amendment of this unrelated subsection would not override either of those.
Mr. Ward, what is the state's position as to whether a vehicular homicide by intoxication defendant who's been convicted can serve part of the sentence in community corrections after serving the mandatory minimum?
So, Your Honor, I don't believe that the two statutes at issue here directly would address that. However, in looking at the community correction statute, the community correction statute speaks in terms of nonviolent felony offenses, and there's prior case law characterizing vehicular homicide by intoxication as one of these offenses, as it's an offense that results in a serious bodily injury or death. So while these specific statutes at issue, probation eligibility and vehicular homicide by intoxication, don't necessarily speak to that question, this court's prior case law has addressed that.
So you're saying that under the community corrections statute and the court's prior case law, vehicular homicide by intoxication would be ineligible for community corrections?
That's my understanding of the jurisprudence of this court and the Court of Criminal Appeals on the issue.
So the term probation is not defined in the statute, is it?
No, Your Honor.
So what are, you've cited some case law, some surrounding statutory provisions, alternative sentencing statute. Did you consult dictionary definitions, and do they provide any support for your position about the meaning of probation?
Your Honor, I can't say that I can recall off the top of my head a specific dictionary definition of probation. I think the best evidence of what probation means in terms of this statute, this court has previously commented that the sentences of split and periodic confinement are probated or probationary sentences. And I think there is sort of a common everyday understanding of probation as this sort of legislative largesse on alternative sentencing where a defendant does not have to serve their sentence in confinement, but is allowed to do so on probation. And on that point, I want to direct this court's attention to the authorization statutes for split and periodic confinement and to the alternative sentencing statute itself. All of these statutes treat the sentences of periodic confinement and of split confinement as essentially types of probation. The way I've sort of conceptualized it in my head at times is probation plus. What the authorization statutes specifically say, the split confinement statute provides that a defendant receiving probation may be required to serve a portion of their sentence in continuing confinement. The periodic confinement statute is very similar. It says a defendant receiving probation may be required to serve a portion of their sentence in periodic confinement. Your Honors, the problem with these sentences and a defendant convicted of vehicular homicide by intoxication is that defendant is not eligible for probation. So they cannot be a defendant receiving probation who is then required to serve a portion of their sentence in split or periodic confinement.
Let me see if I understand the bottom line of what you are arguing. You're arguing that in 2015, the legislature amended the statute pertinent to vehicular homicide to say that a defendant convicted of that offense, first offense, must serve at least 48 days, mandatory minimum sentence. And then just a several years later, enacted another statute that said that same type of defendant, first offense of vehicular homicide, must serve the entire, 8-year sentence? I can't remember exactly how long. Incarcerated. There can be no variation from that, no split confinement, no anything. Am I understanding your position correctly?
Your Honor, that is my position because that is what the legislature did. It would have been easy for the legislature to add vehicular homicide by intoxication to a list of offenses for which full probation was not an option, but perhaps split confinement and periodic confinement were. That would have been a rather elementary statute to write. They did not write that statute. What they instead did was they added vehicular homicide by intoxication into a pre-existing list of offenses that are not eligible for probation. So it's not that the state's position is that the legislature intended to do this.
That is your reading of
the legislature's
these
actions
statutes
indicate
together.
this. Yes, Your Honor. And this reading is gleaned primarily from the plain language, but also from a long line of cases from primarily the Tennessee Court of Criminal Appeals interpreting the statute in this way. I cite to several of these cases in my brief, Burge, for example, and Wheeler, to name a more recent case, where the Court of Criminal Appeals has said that a defendant is not eligible for split or periodic confinement because they either received a sentence that exceeds 10 years in length or because they committed an offense that is on this enumerated offense list.
And do you agree that your reading of that section requires us to ignore most of 3913, 213, subpart B, or Part B?
To the extent that this court views subpart B as sort of guaranteeing some eligibility for probation, perhaps.
Well, I mean, we have to ignore the 48-hour minimum and the 48-hour minimum, the 45-day minimum.
It does have some effect on that statutory scheme, Your Honor.
Well, it has more than some effect. We have to disregard those minimums, don't we?
Well, Your Honor, I will say those minimums will still be served. It's not as if the primary legislative intent of adding those mandatory minimums
you
was
serve
to
10 years, you also serve 48 hours, is that what you're saying?
I mean, Your Honor, that is to some extent true, and I'd like to note when we're discussing this addition of this mandatory minimum language to the vehicular homicide by intoxication statute, I do think it's helpful to consider the state of the law at that time. At the time these mandatory minimums were acted, there was this sort of quixotic feature of Tennessee law that would allow a defendant convicted of vehicular homicide by intoxication to receive full probation, whereas a defendant convicted of DUI, a serious but less serious offense than vehicular homicide, that defendant could not receive full probation. It's that specific problem the legislature was trying to remedy when it added this mandatory minimum language, and that's clear both from the language of the statute and from the legislative discussion around the addition of that language. The legislature, when it amended 3913-213, wasn't in any way trying to guarantee eligibility for probation. It was trying to set this sort of initial floor at which potential eligibility under the terms, conditions, and limitations of the probation eligibility statute could be possible. It then later amended the probation eligibility statute, added vehicular homicide by intoxication to the ineligible offense list. So, Your Honors, in looking at these two statutes, yes, the legislature did in 2015 take some steps to prevent full probation for defendants convicted of vehicular homicide by intoxication. Justice Campbell, you noted earlier that while defendant is arguing that the probation eligibility statute can be read as only preventing full probation for a defendant convicted of vehicular homicide by intoxication, the vehicular homicide by intoxication statute already did that. It included this minimum mandatory language that's outrightly preventing full probation. Well, then 1 year later, after preventing full probation in the amendments to the vehicular homicide statute, the legislature goes further and adds it to the ineligible offense list. Your Honor, I see no way to sort of square the circle here in looking at an offense on the probation ineligible list with the conclusion that that defendant is somehow eligible for a probationary sentence. And I don't believe there's any question that full and split confinement are principally, fundamentally, probationary sentences. Their authorizing statutes say that. This court's discussions of those types of sentences in Bartholomew and in Ray versus Madison County treat them as probationary sentences. So when a defendant commits an offense that makes them ineligible for probation, I believe the most natural reading of those statutes is that that defendant is then ineligible for other probationary or probated sentences. Ultimately, Your Honors, the defendant's position does not look to the plain language of the probation eligibility statute. It instead relies on, and I believe defendant admits that it relies on this unused language, this language of full. And I think the Court of Criminal Appeals perhaps put it best in its opinion when it correctly noted that the probation eligibility statute simply does not limit itself to eligibility for full probation. That's not how the statute is written. This court has on numerous occasions rejected this sort of statutory interpretation approach that relies on the insertion of unused language and has described it in the Stratinko case, which I point to in my brief, has described that as sort of frustrating the intent of the legislature by looking to unused language rather than the plain language used by the legislature. The plain language is the best evidence of the legislature's intent. And the plain language of the probation eligibility statute is that a defendant convicted of vehicular homicide by intoxication may not receive probation. Unless this court has any further questions, I would ask that the judgment of the Court of Criminal Appeals be affirmed.
Thank you, Mr. Ward.
Thank you, Your Honor.
Ms. Tennant?
Thank you, Your Honors. Justice Kirby, you asked about what standard this court should use in its initial approach here, and that is clear from the case of Shorts versus Bartholomew, which the state just referenced, and that is, unless a newer statute expressly repeals or amends an older one, the new provision is, as a starting point, presumed to be in accord with the same policy embodied in the older enactment. And I think that starting with that approach makes it clear that what the court's job is to, at the very first, if possible, make these statutes work. That's what the trial court did when it looked at these two directives, and that's what I'm asking this court to do today. Justice Page, I think you asked about community corrections and eligibility and whether or not a decision here on probation would also preclude or even speak to community corrections eligibility. The state referenced the vehicular homicide offense itself as being possibly precluded on its own terms through case law. However, there is always the special needs provision. That was not ever examined by the trial court because the trial court conducted a certain statutory analysis and decided that Ms. Robinson was eligible for a sentence of split confinement and periodic confinement. The court never got to a community corrections sentence. Her sentence length here is 10 years. It is a probation eligible sentence, and it presumably could be, if a finding of special needs were made, be eligible for community corrections. Therefore, the legislative policy here, again, is not necessarily clearly prohibitive of a sentence involving release into the community. During the state's argument, you guys talked about what probation means. Probation primarily means release into the community. I don't think the basket statutorily extends to community corrections, but here when you're looking at the policy embodied within the legislation, you can look at probation as being a fairly large basket of release into community. That's how a split confinement sentence works. We have a sentence of confinement combined with release. That's how periodic confinement works as well. Periodic situations of confinement in jail combined with release into the community. As a final sort of statutory interpretation mode that this court should look to is that criminal statutes are to be strictly construed in favor of defendants. There's a long-standing policy among the courts to resolve doubts in the enforcement of the penal code against the imposition of the harsher punishment.
But that's only if there's a grievous ambiguity in the statute. That's not a general rule of interpretation. It's if the statute is ambiguous, then the rule of lenity comes into play. But there's not sort of at the outset a thumb on the scale in favor of, I guess, construing the statute in favor of the defendant.
I think the rule of lenity certainly comes into play when there's an ambiguity, but the rule of strict construction, just that looking at the statute by its very terms and making it and resolving it against the imposition of harsher punishment, the way I saw that in some of the case law, it doesn't necessarily invoke the same ambiguity requirements as rule of lenity when that's discussed. I'm looking primarily at a United States Supreme Court case from 1955, Bell versus U.S. 349 U.S. 81 at page 83. Finally, Your Honors, the practical effect of the state's argument here would be to render all of this text in 3913.213, if not completely superfluous and inoperative, very much largely so. I think it would be an extremely confusing place to have so many words just have no meaning within the statute that prescribes the penal conduct itself. And I'd ask this court to affirm the sentence and the legality of the sentence imposed by the trial court in this case. Thank you.
Thank you to both counsel for those excellent arguments and for the good attention of all our guests today. And we will adjourn. Thank you.
All rise.